Welcome to the second session focusing on strategies to ensure compliance with international law. This session introduces some of the most commonly used strategies to enforce international law by states and international organizations. We are starting with those that I have categorized as confrontational in the former lecture, that is, those strategies that seek the compliance of another state or non-state actor with international law by putting pressure on them through a negative and unwanted consequence in case they don't comply with international law. A separate recording will examine the role of the Security Council and the General Assembly in enforcing international law, as I have already said, especially in the context of preserving peace and security. So we are starting from the ones named at the bottom of this diagram and moving up, starting with technical assistance. I have included technical assistance and foreign aid both in the category of cooperative and confrontational approaches to enforcement. This distinction is mainly linked to the existence sometimes of conditionalities attached to this kind of measures. So sometimes states or non-state actors will condition the provision of technical assistance and mainly foreign aid to the beneficiary complying with certain conditions. These conditionalities may undermine the sovereignty of the beneficiaries in a not so symbolic arm-twisting exercise where some states are forced to adopt a specific economic or social policies or do something else to receive assistance. Therefore, states can use foreign aid and technical assistance to force compliance with other rules of international law, or they can use them as an incentive, so as a confrontational approach or a cooperative approach. This will much depend on the context. The European Union, for instance, has been widely criticized for its use of conditionalities. The same is true about the International Monetary Fund and its structural adjustment policies. Large number of developing states united under the Group of 77, another political alliance from the South, are opposed to coercive approaches, imposing political and economic conditionality attached to the compliance of international law. These conditionality are predominantly perceived as unethical, ineffective, and counterproductive, as well as impossible to implement in practice. International organizations can also use sanctions to enforce international law. While sanctions is a terminology traditionally reserved for measures adopted by international organizations to force the implementation of international law, the truth is that the terminology is also used in common language and even by international lawyers to refer to actions adopted by states. Here we will use them in the most limited way, and the term sanction will refer to those confrontational measures adopted by international organizations that seek to force compliance of international law by imposing a coercive measure on a state or another non-state actor. Still, the terminology might vary depending on the international organization. So, for instance, the European Union calls them restrictive measures, but the African Union do call them sanctions. The Arab League used them for the first time against Syria in 2011. I'm just mentioning them here, and I will only cover in a bit more detail the regime of sanctions emanating from the Security Council, with some reference to the General Assembly's role in enforcing international law, as I said in the last recording addressing this topic of enforcement. However, I want to underline that this regime of sanctions is widely used as an instrument of enforcement by many international organizations, and they normally have an economic nature. As we have seen, states and non-state actors can resort to international settlement of dispute mechanisms to resolve their conflicts and prompt compliance with alleged breaches of international law. So this is another strategy of enforcement, to bring a state to a third body. I have written here adjudication and included it within confrontational approaches to enforce international law. However, as I have already explained, a key characteristic that tends to distinguish between settlement of disputes that are categorized as political rather than legal is the attempt to find a friendly solution, a compromise. It is possible to say that attempts to prompt compliance of international law through diplomatic, political settlement of dispute mechanism tend to fit better within cooperative approaches of enforcement, while the adversarial approach that characterizes legal mechanisms will fit more neatly within the confrontational category. I refer to the explanations on settlement of dispute that we have already covered. You can also use reprisals of countermeasures to respond to an unlawful act. Remember that they are themselves illegal acts, breaches of international law. These measures breach international law, but they are one of the circumstances precluding wrongfulness. I have already explained countermeasures and the conditions that should be met in the context of the sessions covering international responsibility. Please refer to these explanations. I have even included the specific minutes where countermeasures have been explained. Let's look into the measures that fall into the category of retorsion with a bit more detail. States can react to a breach of an international rule by using retortions. These are unfriendly gestures not involving a violation of international law. Because they are not illegal in themselves, they do not need to respond to a previous breach of international law, but they often do. Examples of retortion include breaking diplomatic relations with another state or expelling its ambassadors. For instance, in 2017, Saudi Arabia led a coalition of states that first included United Arab Emirates, Bahrain, and Egypt, and accusing Qatar of supporting terrorism. As a response, these countries decided to break diplomatic relations with Qatar and banned Qatar-registered planes and ships from using their airspace and territorial sea. They just imposed a blockade through land, air, and sea. In this scenario, the blockade might be a bit different because there were other agreements, but definitely breaching diplomatic relations is not unlawful in itself. However, you can see also how it's difficult to distinguish between retortion and countermeasure. The measures was here in response to an alleged violation of international law. It was alleged that Qatar had violated the 2014 treaty with the members of the Gulf Cooperation Council, an organization to which Qatar is a member. Progressively, also other states joined the Saudi-led coalition and demanded that Qatar reduced its international engagement with Iran and Turkey, and also that it closed Al Jazeera. At the end, with the mediation of Kuwait and the United States, an agreement was reached very recently in January 2021, finishing the conflict and restoring the diplomatic relations between the states involved. The blockade by land, sea, and air that was imposed had a strong impact on the people of Qatar, And it is possible to argue that in this case, the measures may have had the impact of breaching international law by, at the very least, interfering in domestic affairs of Qatar, and that they might fit better with the figure of countermeasures than retorsion. Indeed, it will not be always easy to distinguish them. Another typical example of retortion is the imposition of visa restriction. For instance, the Trump administration imposed new restrictions to members of the Chinese Communist Party who wanted to travel to the United States in December 2020. Another typical example is the withdrawal from existing treaties or membership to international organizations if states are not happy with them. We have seen plenty of recent examples where states like the United Kingdom have threatened to leave the European Convention on Human Rights. I mean, in the case of the United Kingdom, they left the European Union instead. Trinidad and Tobago, as well as Venezuela, have withdrawn from the Inter-American Convention on Human Rights and therefore from the jurisdiction of the Inter-American Court on Human Rights. An extreme example is the case of the South African Development Community Court. That was the court attached to the South African Development Community, an international organization. The court itself was created in 1992, but totally dismantled in 2011 over the fallout that followed its ruling over land rights in Zimbabwe. Again, states members of the organization are completely within the rights of dismantling the court, but this is clearly a retortion to the work of the court of an extreme nature. As you have probably seen in the news many times, the United States has used withdrawal from international institutions in multiple occasions as a form of retortion against decisions it has disagreed with or as a way of pushing reforms it wanted implemented. This has been obviously facilitated by its power in international relations and in particular its the strong dependence on US funding by these international bodies. So we have seen this kind of behavior recently towards UNESCO, the UN Human Rights Council, and many others. Finally, a widely used mechanism to enforce compliance is naming and shaming. Using publicity to point to those who are breaching international law is widely used in international relations. This can probably be included among other forms of retortion instead of a separate category, but is so widely used by international human rights bodies and institutions that I wanted to name it separately. Many believe this is a pointing fingers exercise that has no real impact, a mechanism without it. However, available data suggests otherwise. For instance, a bad human rights report or a bad human rights resolution has a massive impact on the foreign aid a state will receive. I have done quite a bit of research on this and I'm happy to share if you drop me a message. But for now, this will end this quick overview of confrontational approaches to enforcement.